Good morning, good morning, good morning. It's a little bit of an earlier coffee and Cursey words because after this, I am on a flight to BravoCon, which means today will be an interesting day. It always is. I made myself a glorious cappuccino this morning. I am so excited to drink my coffee. I'm so excited to drink my coffee. So I was torn between not doing a stream, trying to do a stream tomorrow, which is the first day of BravoCon, or trying to do a stream a little earlier. I know it's early for the West Coast, but I really, once these documents dropped yesterday, I was like, we need to talk about it. And I feel like the community of those who enjoy watching lawyers on YouTube have not gotten to talk about law very much lately, which is both embarrassing and tragic for me. So all of us want to just talk about some freaking law for a minute. It's time to just do what we do, which is all that we do over here. We're going to be covering Amber Heard. Johnny Depp also filed motions. Yeah, don't ask the media to cover that because they're like, Amber Heard did this. I'm like, Johnny Depp did too. I'm feeling a little sassy this morning. Maybe it's because I'm a little tired. Melissa in the chat said, I know about TwitchCon and Comic-Con. Well, there's also a VidCon, but BravoCon, yes. TwitchCon, no foam pit, hopefully. TwitchCon, Comic-Con, that kind of con, but with Bravo celebrities, housewives, panels with podcasters and housewives. You can photo ops with housewives. It's very much a con, but with Bravo celebrities. And since I cover so much Bravo, I am very excited to go see the humans in person and to say hello to not just the traditional reporters who I like very much that are going to be there. Who there are some particularly from people that I just adore and I cannot wait to see them. So we're going to be doing that. And then the other podcasters in this space, Bravo Docket's going to be there. Very excited. They cover so much in the Bravo reality TV world. Ryan Bailey, Up and Adam, and his fiance Jason will be there from the Hot Messy podcast. Lots of podcasters. Sarah Galley from Andy's Girls and Heather McDonald from Juicy Scoop. I'm really going to see the people. I want to go see the people. I want to run around with my people. I want to see my people. So, I'm going to have some coffee. Let me know what you're drinking, where you're coming in from. It's so good. I already see you guys coming in across the interwebs. Good morning from Michigan. Good morning. Good morning. Good morning from the UK. Good afternoon. That's what you both said. Good afternoon from the UK. My brain fills things in. I apologize. It's been a while. Love the deeper purple hair. The deeper purple happened yesterday. Wonder if Erica Jane will be there. She's supposed to be, but I don't think Jen Shaw will be there, but we'll see. Hi from Japan. Fresh hair from BravoCon. Olivia. Yeah, I have limited things going for me. I am not a stylish human. I wear basic black. I wear sneakers. They're fun sneakers, but I wear sneakers. My zhuzh stays here. That's it. So yes, we had to freshen up the hair. We freshened up the nails. We freshened up the hair. We're ready. Good morning from Pigeon Forge, Tennessee. We have not been there yet. I can't wait. During the trial, you said you're in Middle Tennessee. I'm in Nashville. Jen, I am in Middle Tennessee. The members know this because yesterday my husband came in. He's like, the tornado sirens are going off. And Nashville severe weather says there's spinny bits. That was my words, not his. Spinny bits on the radar, and it looks like things are spinning up in a way where we may need to imminently take cover. And the members are like, please log off the internet and go take cover from the tornado sirens. So yes, Middle Tennessee, we did that yesterday. I saw these were the other YouTube lawyers. I was waiting for you to cover the appeal docs. Of course, we're covering the appeal docs. I'm sure that I believe Rick Hogue covered all of it this morning as well on Hangouts and Headlines. I popped into the chat a little bit as I was getting up this morning. I was up late packing because it causes me stress. It causes me stress. It does. So it's so good to see you all coming in. I'm going to roll the intro. We're going to get into it. I'm going to try to get to some questions about the TwitchCon thing. I will talk about it at some point. I'm horrified by what happened at TwitchCon. As someone who's had a spinal fusion, who has had nerve issues with my back, I had a visceral reaction to that video, and then to the creator that got hurt sharing out on Twitter how hurt they got. Just it hurt my stomach. And Attorney Tom has a great video on it already. For those of you that don't know, I see a couple of you saying what happened. Cynthia, TwitchCon, or one of the booths at TwitchCon by Lenovo and someone else, had like jousting, like American Gladiator style jousting, where they had little like 2 foot or 3 foot tall little podiums, and you could joust with like noodles, and then there was a foam pit. Multiple people got hurt in the foam pit. The foam pit didn't seem to be adequately foamed or deep enough for excuse me, for it to protect people. And one of the creators jumped off of the little podium that was only a few feet tall, but jumped off the little podium into the foam and broke her back in multiple places. Excuse me, I'm talking too fast for my own throat. Broke her back in multiple places, had to have very, very rapid surgery. It seems that the foam pit, to me, was not deep enough, not adequately done. It's horrifying to me. But Attorney Tom is, if you don't know, a very tall catastrophic injury attorney. And so he has a video on it. His video was shouted on Phil DeFranco yesterday with the rudest screenshot I've ever seen. So if you watched Phil DeFranco yesterday, Tom's screenshot is like Tom, congrats on the screenshot, buddy. So he talks about the waiver. He talks about the accident. We'll talk about it. We'll talk about it later, but it's horrific. It's just so sad. It's just so sad. And it was like the blocks of foam. Pamela C's absolutely right. It was like the blocks of foam and then concrete. So it's not surprising that people got injured. Foam pits are supposed to be at least like 1.5 times as deep as the thing you can go off of and all this other stuff. It's just terrifying. It's just terrifying. Lawn Lumber said, Emily, why are you so early? I wanted to nap before coffee and Cursey because I have to get on a plane during coffee and Cursey time. And so I had to talk early or not talk today. And not talking today truly was not an option. Let's be real. Was not an option. I've missed you all. I missed you on Tuesday. It's such a crazy, like, fall is so busy. It's just so busy. Okay, let's just get into our talk. I forgot to roll the intro. Rolling the intro. Let's just talk. We got to talk about the things. I need to have my cappuccino. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. Camille was saying that I'm from Ann Arbor, Michigan, folding laundry and drinking coffee. The amount of YouTube I intake while I'm doing household things is insane. And I will come into the chat and people will be like, Emily, jump on the stream. And I'm like, you're so generous. Thank you. I don't want to ever pressure a creator to be like, hey, because I'm a whole lot. I never want to pressure a creator to be like, hey, let me on your stream. First of all, though so many creators are so welcoming, but if you've got a whole show planned and you don't plan for a guest, I'm a whole lot of a guest to have sprung on you, which I understand. But most of the time I'm like, reorganizing my closet again, or putting things away, or cleaning things, or like rounding up my plants to do like house plant care. Like I'm generally doing stuff. So normally I'm in the chat being like, no, I'm just here in the chat because I want to watch. So I want to be the person in the chat sometimes because I love chatting with y'all. I love being here. I love our mods. Zoe says, I work at Starbucks, so come get your coffee for Cursey words. I mean, cheers. We had such a hard time finding pumpkin cream cold brew down in Huntsville. It was sold out at like 3 different places. I was so bummed. Oh my God, I am just on break trying to get appeal info, and Emily is live and with your appeal info. This is the most clickbaity you'll ever see a title for me because in the thumbnail, I put appeal with an exclamation point and not a question mark. That's the wild YouTube-ness that's happening for me today. So y'all do the YouTube-y things. Don't forget to do the likey, subscribing things. Thanks. Okay, thanks. We're professionals here. Let's share our screen. And we're going to get into this first article I saw. I know that Hogue broke this down on Hangouts and Headlines this morning. He was very generous of inviting me on. It was just too early because I knew I'd be up till like 1 a.m. packing because ADHD. Because ADHD does not let you. This is little known fact. It's science, I'm sure. I'm sure it's science. I'm sure it's science. ADHD does not let you pack at a reasonable hour. I was talking to my friend Warren, Octonation, who was traveling to California this morning. We were on the phone at like 8 o'clock maybe. And he's like, I've got to pack. I'm like, I've got to pack too. And he's like, my flight's at like 6 a.m. I'm like, oh, mine's not till the afternoon. And this morning I'm like, safe travels. He's like, I didn't sleep. Accurate. So with me speed talking, let's take a look at this article that I have a few issues with, but zen, and then we're going to get into the actual facts. Amber Heard sets her 16-point grounds for appeal. The actor who was recently spotted in Spain retained David L. Axelrod and Jay Ward Brown of Ballard Spar for the appeal. Yes, true. Yes, she sets her points for appeal. On Tuesday, Amber Heard filed an appellate brief listing 16... No. We're going to pull up the actual documents. This is why I hate covering things without having the documents. And we're going to talk about Andrea Burkhart from over on Twitter, has a YouTube channel, defense attorney, great coverage, calls it like she sees it. Andrea Burkhart posted the documents. Thank fucking God for her. Because I was texting Rob yesterday as this article came down, and I'm like, did you see an appellate brief? Did I miss something? Because the ADHD, I always assume that I've gotten it wrong. That I've missed something. So I'm like, did I miss something? Was there an appellate brief? No, the answer is no, there's not an appellate brief. It's not an appellate brief. Doesn't Vanity Fair have lawyers? Vanity Fair, call a lawyer. It's not a brief. Everybody's like, where are the grounds for appeal? Well, they've got a few grounds for appeal, but then it's not the reasoning. The appellate brief includes the arguments, the law, the facts, the transcript designation. So-and-so said this at this time, all of it. This is just the grounds for appeal, and we'll get into it. Thank God we could actually go to the source documents, because this is where this game of telephone with the mainstream media gets totally fucked. Because all the other reports I've seen have come from this report, and this report is wrong. It's not an appellate brief. Incorrect. It did list 16 grounds for appeal, but a brief has argument, law, and things. 4 months after a jury awarded her ex-husband Johnny Depp $10.3 million in damages during the trial, which ended in June. Has it been that long? Depp claimed he had been defamed by a 2018 op-ed Heard wrote at the behest of the ACLU in support of victims of domestic abuse. During the trial, Depp claimed, and the jury found, that he had been defamed by Amber Heard. That she shopped around to multiple outlets and settled with the ACLU because it was the best for PR. That is what the trial showed us. To be fair, this is generously skewed to be favorable to Amber Heard, in my opinion. My coffee cup is too small this morning. The opinion piece does not refer to Depp by name. And, because put relevant shit in your article. But he successfully argued that readers could infer she was talking about him in two of its sentences and its headline. Yeah, the jury believed. I think the jury believed. The opinion piece did not refer to Depp by name, but the jury believed that readers could infer she was talking about him in two of its sentences and its headline, Amber Heard, I spoke up against sexual violence and faced our culture's wrath. That has to change. The jury also awarded Amber Heard $2 million in damages for her countersuit over a statement that Depp's lawyer, Adam Waldman, made in which he called her claims of abuse a hoax. See, the problem is, for me, and maybe I'm being picky because I'm a lawyer. Am I being picky because I'm a lawyer? Let me know. This is why I hate covering cases that we can't see or I don't have the documents for, because this is also not right. Yes, the jury awarded Heard $2 million for statements that Depp's former lawyer, Adam Waldman, made. Correct. In which he said that she and her friends staged the location, spilled a little wine, roughed shit up. That is the only area where they found that it was defamatory. And the evidence at the trial showed, I'm not done sidebarring yet. The evidence at the trial showed that that's not exactly the way that it went down. But there were statements saying that she created a hoax, and those were found to not be defamatory. So, no. Did anyone watch this trial other than all of us? Because at verdict, there were 300,000 of us on this fucking channel watching it go down. How is this not just known? Or is it deliberately disingenuous at this point? Is it just deliberately, willfully disingenuous? I have questions. Why not just put the facts in? This doesn't seem to be an opinion piece. I mean, it's in the style section, I guess, but this doesn't seem to be an opinion piece. It seems to be factually reporting that an appellate brief was filed, which it wasn't. That Johnny Depp defamed Amber Heard by saying her claims are a hoax, which is not what the jury found. And that the ACLU is the one behind all of this, which they aren't. Amber Heard was shopping the article, and that's just the first paragraph. According to documents obtained by Vanity Fair, and thankfully Andrea Burkhart, whose Twitter I will share in a minute, the grounds for appeal include everything from a lack of clear and convincing evidence for actual malice, the standard whereby defamation cases are decided. Is this thing on? Clear and convincing evidence of actual malice is the standard in Virginia for malice against a public figure. There, I fixed it. To the trial court's failure to invalidate the damages award that the jury assigned after it found both Heard and Depp had defamed each other, an inherently an incredibly inconsistent thing. I've talked at length about why the jury's verdict's not inconsistent. We're going to do that again. Some of the grounds had already been mentioned either in court or in post-trial interviews by her former representation, Elaine Bredehoft. Her trial counsel, I mean, it's fair to say trial counsel, Elaine Bredehoft. It's trial counsel. You generally get other appellate counsel. Look, I was excellent trial counsel. And then there was an appellate division that I wanted no part of ever because I am not an appellate attorney. Why? They don't get to talk much. Can you see where the problem would be for me? It's like, oh, that's not the talky part of law? Dude, fuck that. You have to write things, long things with all kinds of key sites and footnotes. I'll footnote this way. Footnote. Blarg. So there were a few surprises. The surprise is that you didn't mention Johnny Depp filed one at all. Surprise! Several of the points have to do with evidence admitted that should not have been, they say, and evidence that was not admitted that should have been. We knew that, including various communications with medical professionals as well as employees, friends, and families. In another point, the filing reads, quote, the trial court erred in allowing Mr. Depp to argue or suggest that at trial that the jury could award damages based on statements or conduct occurring prior to the publication of the challenged op-ed. I don't remember that argument. You know what'll be great? What'll be great is when we get the appellate brief and we see the quote from the closing argument that shows that they argued that. I'd love that. I'd love to see that. But we don't have that yet because the appellate briefs haven't been filed yet. That is, Depp was suing over the op-ed and thus claiming he lost work and was owed damages because of it, but Depp led members of the juries to believe that Heard was on trial for statements or events prior to the article's publication. They reached a settlement for divorce in 2016. Actually, wasn't the settlement for the divorce signed in 2017? I think. Maybe not. In August, a spokesperson for Heard announced that she had parted ways with Bretta Hoff. I mean, it goes to another article. She hired appellate counsel. It's really not like dramatic. It would be dramatic if we had evidence that Amber Heard was like, Elaine, you're fired. That would be dramatic. This is just like, you're not appellate counsel. Okay. Well, Ben Rottenborn of Woods Rogers would stay on as co-counsel. That part is interesting, but I think Rottenborn had the better trial strategy. I just don't think anybody listened to him. Ballard Spahr defended the New York Times against former Republican vice president candidate Sarah Palin's defamation case and won, suggesting that they would help frame the appeal more firmly around the First Amendment. Let's see if that happens. A spokesperson for Heard told Vanity Fair in August that, quote, a different court warrants different representation, because that's accurate. It just, when the media makes things that are normal seem like they're not normal, it's confusing for everyone. The filing arrives in Virginia court on the heels of Depp's appearance stateside. He was photographed signing autographs in New York while here with Jeff Beck for a North American tour. He played in New Jersey on Tuesday night. Heard was last photographed in Spain. Because it's a celebrity article, we have to talk about the celebrities. Let's talk about these documents real quick. I'm going to go ahead and put a link to Andrea Burkhart's Twitter in the chat because, and I'm going to give it to Miguelina too so we can put it in the description, because she, of the lawyers in the interwebs, she, Natalie Lawyer Chick, Rob from Law and Lumber, Ian Runkle, Rick Hogue, and others still like work their law jobs, which are a ton of fucking work. I do this and it's a ton of work. They do both. So any support you can give to the creators that you enjoy is always appreciated. Andrea has been so on top of getting these documents, just incredibly on top of getting these documents, and on her website put up all of the documents that were unsealed and crowdsourced them and organized it in a way that my ADHD brain could have never done. And she does work in appeals. She also is a trial attorney. So she's incredibly awesome. She shares this shit on Twitter so that all of us know the facts. The facts. So, legal color commentator, wait, what happened to Robert Guevara? Y'all? See, yeah. Yesterday, briefly, LawTube was trending, and that's when I logged out of Twitter for the day. I didn't know that Robert Guevara got a strike on YouTube. I will address this later. Thank you for sharing this, Andrea. Misinformation strike for the same platform that probably, I don't know who that is. Suspended for 7 days. Attach the letter. I will go share that out later. That platforms owe creators transparency. And if we cannot, because Robert talks about the cases. I've had issues getting age restricted and stuff, talking about legal filings. If CNN, ABC, NBC, Law and Crime, Court TV, if they can talk about legal filings, creators who cover legal filings should also be allowed to talk about legal filings. There has to be some equity on the platform consistently. From everything I've seen from Robert, he talks about the legal filings in a very logical, straightforward, no fluff, not even a Cursey word kind of a way. If you don't like what's in the legal filings, YouTube, I understand, but then you can't let anyone talk about them. You can't just whitelist news outlets and not independent creators. I'm going to get distracted. Or let independent creators submit to be vetted. And some can choose. Some can be like, look, some creators can say, I'm not a fact-based channel. Fine, go ahead. Some don't clip that. And some creators could say, look, I cover legal filings. Can you please take a look at my channel and just put whatever tick mark you put by the news media outlets and see what I do here? Can we do that? What the fuck is happening? Okay. I have more questions. I has more questions. Julia says he got an election misinformation strike for going through a case. They're legal allegations. We have to be able to talk about allegations in cases, even when you don't like the people filing the cases. And I would argue, especially when you don't like the people filing the cases. It's important to have transparency in our legal system. When there isn't transparency in our legal system, really awful shit can happen. But not in this civil appeal. Okay, I'm just going to Robert's tweet and then we'll go back. He's on Watching the Watchers at locals.com. He shared the strike. He shared where his stuff is. YouTube issued a strike against our channel for election misinformation. We're not allowed to stream or post. Yeah, you can't even post in your community tab and tell your community what happened for 7 days. And said, we'll stream the show on Rumble, Facebook, Twitter. After the show, we'll do a locals after party, no payroll, for comments and live chat. If you know anyone in the YouTube chat or elsewhere who might not be here, I appreciate you letting them know. We're letting them know. So this looks like it's coming from his Locals. Locals is an alternative platform, and that's at Watching the Watchers. And we will put that in the, I'll just grab that. We'll put that post in the description box. It's just ridiculous. Not being able to, this is why we have things like the text crew. This is why we have the Patreon, which again, with Patreon, you can follow for free at Law Nerds Unite, and you can get updates and see them. You don't have to pay to be there. You can hit follow. That annoys me so much. It annoys me so much because from what I know of Robert's content, he really does. When I say, like, I'm reading the legal documents, sometimes there's sass. Sometimes I'll tease the attorneys. Robert reads legal documents and gives analysis. We will have a platform problem conversation another day. We had some of that conversation on yesterday's podcast episode talking about Section 230. It's very, very frustrating. At least they told him. They're wrong, but at least they told him. I mean, I should say I need to watch the content, but I know Robert just reads the court filings, and I imagine I'm going with the assumption that YouTube is wrong on this one until I'm proven wrong. Fucking hell. All right. The point was, Andrea Burkhart posted up the designation of assignments of error on her Twitter, so we don't have to rely on Variety. Sorry, Variety. I'm not talking about you. Vanity Fair's coverage of it, because Vanity Fair told us it was an appeal. It's not. It's a designation of assignments of error. So let's get into designation of assignments of error. This is filed before the appellate brief is filed, and it tells the court this is the shit that we think is wrong. And I'm going to have to talk way faster because I have to get on a flight, and I got totally distracted. All right. In the Court of Appeals of Virginia. Yes, it's in the Court of Appeals. Appellant's designation of assignment of error. Not appellate brief. Not an appellate brief. Sue, this is their 16-point designation of assignments of error. It's not a brief. This is what it is. Chocolate and coffee, yes, they are. I talked about it in yesterday's podcast. SCOTUS is absolutely taking up 2 cases with Section 230. Comes now appellant Amber Laura Heard. These are the grounds. This is literally just we think that this is what the court did wrong. And we're going to put all of it into a brief with like facts, hopefully, and law. And it's probably going to be quite long. Rob said there was like a word limit. I forgot what it was, but there's a limit. You can ask the appellate court for more. The judges are like, fuck you, I don't want to read more, but they might. 16 points seems like a throw spaghetti on the wall kind of a thing. The trial court erred in declining to dismiss the action for form nonconvenience. No, they didn't. That's a proper trial court ruling. They ruled there were enough contacts to Virginia that they could do it in Virginia. The trial court erred in denying the supplemental plea in bar in ruling that the November 2nd, 2020 judgment of the United Kingdom High Court of Justice, Queen's Bench Division and Depp v. News Group Newspapers Limited case, that one, does not foreclose Mr. Depp's claim. No. This was thoroughly vetted. I did a whole podcast episode about it. This was thoroughly vetted. Y'all, different legal system, different standards, different defendants. He wasn't suing Amber Heard. No, it doesn't bar his claim here. Stop it. The trial court erred in denying the demur and plea in bar and in ruling as a matter of law that the 3 alleged defamatory statements in the challenged co-op are actionable as statements of fact rather than non-actionable expressions of opinion. They weren't opinion. And B, actionable as defamation by implication. Good luck with that. The trial court erred in excluding from evidence at trial the November 2, 2020 judgment of the UK court. I disagree. I really would like to see grounds where I go, oh, that's interesting. We're not there yet. I would like to get to the, oh, that'll be an interesting argument. I love to see that. Right now we're getting to cry more. God, that was rude. I'm sorry. I'm snappy this morning. I apologize. These have been thoroughly vetted. Let's get to something that hasn't been thoroughly vetted. The trial court erred in excluding from evidence at trial A, medical records, including Ms. Heard's contemporaneous communications with medical providers such as Dr. Laura Anderson, Dr. David Kipper, Miss Debbie Lloyd, Miss Erin, there's not a chance, Dr. Amy Banks, Dr. Connell Cohen, Dr. Bonnie Jacobs, and B, Ms. Heard's communications with several third parties, including Depp's employees, Heard's employees, friends, family, about interactions with Mr. Depp, including reports of drug use, aggressive and abusive conduct, physical abuse, and her fear for her safety. She testified. The time to talk about her fear for her safety was when she testified. The time to talk about the drug use, the conduct, the physical abuse was when she testified. And a lot of these witnesses also testified. So some of these were hearsay. I will be interested to see what they think was kept out and what exception they think it falls under. That one legally I'm interested in. Number 5, mark it down. I'm legally interested in number 5 because I want to know what statements they think were kept out. Probably all hearsay. The trial court erred in admitting evidence at trial related to Ms. Heard's pledge to donate.
It was pledged. They're real salty about that. Gee, I wonder why.
What? The trial court erred in admitting evidence at trial related to Ms. Heard's pledge to donate money to charity and evidence related to Miss Heard's alleged abuse of third parties. Look, that was not improper. The trial court erred in excluding evidence at trial of Mr. Depp's reputation as it existed prior to publication of the challenged op-ed and after the op-ed was published. They brought in a lot of evidence about that, but they do get into his reputation because they're saying it was damaged. Vivi said, "Don't you know pledge and donate are the same things?" Vivi, the little smiley face always gives me these sarcastic vibes. Thank you for giving me the sarcastic indicator, but right? It's synonymous. I use them interchangeably. Damn it. Okay. It is proper in a defamation case to talk about reputation. The trial court erred in sustaining an objection during the cross-examination of Mr. Depp to a question about the truth of one of the alleged defamatory statements on the ground that it called for a legal conclusion. I'm interested to see on this one, I'm interested to see the vignette, like the testimony from the transcript that they will include. I'm interested to see exactly what it was, because I'm really curious. Because asking him if a statement is true shouldn't, in general senses, be a legal conclusion. So I'm interested to see that. I'm interested to see if that was asked exactly that way. Because I suspect maybe it wasn't exactly that way. The trial court, we did that one, number 8. Number 9, the trial court erred in allowing Mr. Depp to argue or suggest at trial that the jury could award damages based on statements or conduct occurring prior to the publication of the op-ed. If that happened, that's accurate. It wouldn't warrant a new trial. I, again, will be interested when we get the appellate brief to see the statements, when will we see the brief? Probably about 30 days from today, I would imagine. Let's see. The trial court erred in allowing Mr. Depp to argue or suggest at trial and the jury to consider whether the alleged defamatory statements in the challenged op-ed were republications of statements Miss Heard made in 2016 in connection with the domestic violence temporary restraining order she obtained against it. I don't think that's what they argued. I'm kind of confused by number 10. Again, this is why I'll be interested to see the appellate brief. I'm a little confused by what they're arguing in number 10, because the republication arguments that I recall at trial, and again, this is construed in the light most favorable to Amber Heard. These are her grounds for appeal. The republication that I recall was her tweeting and adding, "I published this today, blah, 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 blah." Not rehashing. So I'm interested to see, again, with the appellate brief, we should get this is what was said, this is what happened, this is why it's a problem. So we should see that in the brief. So I'm interested to see what number 10's about when they get to the brief, because I don't recall, or I maybe didn't perceive that what Depp was arguing was that this was just the 2016 allegations again. So I'm interested to see where they stand on that, which is why this is not a brief. We don't have all the information. So I'm interested to see what grounds 10 sort out to be. Molly T, we will talk about this as I get to the end of this. I'm going to save your question. It's a really good question. 11. We skipped 11. Don't skip 11. The trial court, which rejected proposed jury instruction, CC, improperly instructed the jury on actual malice. That will be interesting. I will be interested to see what they say the court said and what the actual malice instructions are. Those are proper grounds for appeal that can actually have a big impact. If the trial court did, in fact, misinstruct the jury, that can be a big deal. I'm interested to see grounds 11. I don't recall cringing at it, but we could all go back and watch what the court said if we want to. The trial court erred in denying the motions to strike and set aside the jury's verdict with regard to Mr. Depp's failure to prove publication by Ms. Heard of the statement, "I spoke up against sexual violence and faced our culture's wrath." So the headline, they're still saying that you didn't prove she published the headline. The retweet, this is why the republication mattered. The republication mattered because in the retweet, she said, "Today I published." And the headline was all you saw in, it wasn't a retweet, it was a quote tweet of the article. But Amber Heard made a fair point, or her lawyers made a fair point, that she didn't write the headline. Well, she republished it. She took it in. She talked about writing the op-ed. She talked about why she wrote the op-ed. She talked about the fact that she felt that she spoke up about sexual violence and faced our culture's wrath. She testified about it a lot. It's why I thought it was a critical error at this trial that she testify about the allegations of sexual violence. The trial court erred in denying the motion to set aside jury's verdict with regard to Depp's failure to prove the alleged defamatory statements in the challenged op-ed each conveyed a defamatory meaning about him by implication, and that any such implication was both designed and intended by Ms. Heard. The jury said yes on all of it. The trial court erred in denying the motions to strike to set aside the jury's verdict with regard to Mr. Depp's failure to prove actual malice beyond clear and convincing evidence. I mean, she testified. That's why I wrote it. When she was talking in her testimony about men in Hollywood and about power in Hollywood, and she's like, that's why I wrote the article. The thing is, the jury had to find that she knowingly lied. They didn't believe her. And they're like, you would know if this happened to you or not. We don't believe you. This didn't happen. Life on the road. Are you going to talk about the Cruz verdict? Not now. If the Cruz verdict is in, and I don't know if it is, because I've been streaming. If the Cruz verdict is in and I can summarize it for you later today, I will. But no, we're just going to try to get through this because I have to hop on a plane. If I had a normal live streaming amount of time, 3 to 4 hours, I would try to pull it up and look. But no, I don't have that time today. But I could do short content on it later if I have time. I will try to read what's going on with it on the plane. Let's see. 15. The trial court erred in denying the motion to set aside the jury's verdict in a ruling that the jury's verdict in favor of Mr. Depp on his claims against Ms. Heard and in favor of Ms. Heard on her claims against Mr. Depp were not inherently and irreconcilably inconsistent. They're not. Here's my opinion on why they're not. My opinion, my analysis from everything we watched in this trial. The verdict for Amber Heard that Johnny Depp's former lawyer defamed her, and that lawyer was an agent, and therefore Depp defamed her, was very factually consistent, or very factually heavy. And the jury found that those facts weren't consistent, because the way Waldman described it and the way the police described it were different. So I think they found that's not true and found malice. I don't know how they found malice there. How did they find that Waldman knew that those statements weren't true? I don't know. But they found what Waldman said went down is not what went down the night that wine was spilled and the police came and whatever. They found it to be defamatory. Okay. That's separate than the statements that she made about Depp. And they didn't find defamatory the statements about her statements being a hoax. And if her statements are a hoax and are a lie, then her defaming him with those statements is not inconsistent. I don't think they're inconsistent. I thought when the trial started that you couldn't find for both. But as we saw the testimony go, I understood how they could find the two, but it wasn't until I saw the police officer testimony juxtaposed with the statement by Waldman that I went, oh, I can see where they can find that. At the very beginning of the trial, I was like, I don't see how they could find for both. Somebody wins, somebody loses, or they both lose. At the end of the trial, after, watching all of the testimony and evidence, I was like, oh, I see where I see how they did that. And you can watch my verdict stream. I believe I talked about it there. The trial court erred in denying the motion to set aside the jury's verdict and upholding the amount of jury damages awarded in light of A, Mr. Depp's failure to prove pecuniary damages, and B, the excessiveness of the compensatory and punitive damages. I'll be interested to see their legal argument on that. The damages are too much. We've seen a lot of these arguments already in the motions that I covered with regard to motions for new trial. And the trial court was like, no. So I think some of these are probably too much spaghetti at the wall. I think it would be my preference. I mean, I'm thinking if I'm a judge, I want to see your best arguments on appeal. I don't want to see just some random bullshit. Some of these feel like random bullshit to me. The pledged versus donated thing, they feel they have to argue it. Fine. Some of this appeal, I still think, and we haven't seen it yet. But when we see the appellate brief, I think some of this will be another way to seed their view of the case into the media that picks up and runs with their view of the case. I hate being that cynical, but some of it's going to be PR. It just is. Shall we look at what Johnny Depp filed? Because from reading the media articles, you wouldn't know he filed shit at all. Let's do that. Johnny Depp also filed his designations of error. Why? I imagine it's because that's when they were due. It's yesterday. Or Tuesday. What day is it? Tuesday. I imagine that's when they were due, and that's why they filed them at the same time. And then we'll talk about how the rest of the appellate process works and answer 6 questions. It was an oddly specific number. We'll answer a few questions before we got to go. And replay crew, always love you the most. If you leave questions in the comments sections, just put your question mark. I will be on a plane, but I will have Wi-Fi. I paid for the Wi-Fi package for the fall because I need it. I will be on Wi-Fi, so I will go in and try to answer those. And then I intend to create some reels today to answer some of those. So I will create some shorter content to put up on my Quick Bits channel to answer some of those things. So if you have questions after this, pop them in the comments, and I will try to answer. I will be in the comments when I'm on the plane to try to get to as many as those as I can, because I'm not going to have as much time for questions today. And I appreciate you being here and watching and subscribing and doing the YouTube things. So, and then we'll get to questions. Let's look at what Johnny Depp's team has to say. Court of Appeals, Appellant, John C. Depp's assignments of error. These are the grounds we're appealing on. This is not our appellate brief yet. This is our preview. The trial court erred by denying Mr. Depp's motion for summary judgment as to Appellee Heard's counterclaim and Mr. Depp's motion to strike the evidence as to Miss Heard's counterclaim. You shouldn't have let the jury hear the shit about Waldman at all. It wasn't sufficient to go to trial. A lot of her counterclaim got yeeted. There's subparts. A, Mr. Waldman is an independent contractor, not an employee agent. And Mr. Depp is not liable for Waldman's allegedly tortious conduct as a matter of law. That's an interesting legal argument. I'll be interested to see it. Employees, you generally have some control over how they do things. Lawyers, you don't really have control over how they do things. You can be like, can we sue someone? And the lawyer can be like, not really. Or the lawyer can say, yeah, but on these grounds. You don't have control over a lawyer that you hire so much as you would have control over an employee. This would be different if this lawsuit's against Mercedes and you're trying to sue their in-house counsel. In-house counsel's an employee, but it's a little bit different here. I think it's an interesting argument. I don't know how the appellate court will see it. I'd like to see the law on this. I'm actually interested in the contractor versus employee and how someone's liable for what their lawyer said when their lawyer may or may not have been speaking on their behalf in a formal way. We'll see. B, the statements by non-party Adam Waldman that are the subject of Miss Heard's counterclaim are not actionable statements sufficient to support a claim for defamation. That's already been denied. Those motions have already been denied. They've already made these arguments. We'll see. Subpart C, Ms. Heard failed to present any clear and convincing evidence that Mr. Waldman made the counterclaim statements with actual malice. I think there's room for that. Oh my God. It's look, this time of year, man, California, the level of humidity did not change significantly, but I also live by the beach. Middle Tennessee, man, in the summer, they're like, hey, the air is water. In the winter, it's like your flesh is going to fall off because it is so dry. This is my second round of hand lotion this morning because I literally feel like my flesh is peeling off. All right. I'm a Californian. We get very, very pampered living in a very consistent climate. And this climate is just like, hey, welcome to the roller coaster, motherfucker. Let's go. All right. Sorry. Ms. Heard failed to present any clear and convincing evidence that Mr. Waldman made the counterclaim statements with actual malice. I am very interested to see how they will argue this, because what did they do to prove that Waldman knew that the statements were untrue? Because they didn't prove how he was told the statements or what he knew about the statements. I am very interested in this particular argument. Very, very interested in this. Why is there more? Okay. Preserved. Plaintiff's memoranda to sustain demur, plea, and bar to all counterclaims. Oh, is this the evidence they're going to use? Is this the record they're going to use for this argument? I love that they noted that. I don't know if they're required to, because Amber Heard's team didn't, but it seems like this is what they're going to use to support this particular point. So the plaintiff's memoranda to sustain demur, the plea and bar to all counterclaims, which motion the parties argued before the trial court on October 16th, 2020. So this is the site to where those documents live in the record that they've already submitted to the appellate court. The trial court denied on January 4th with respect to the three statements that ultimately formed the basis for the counterclaim, where that will be. Plaintiff's memoranda support a motion for summary judgment regarding counterclaim, where that will be. So these are citing the appellate court to where they've already sent that information. Like, these are our bait stamps. Which motion the parties argue before the trial court on March 24th, 2022 is further reflected in the court's order. There's the court's order on the record. Plaintiff's memoranda in support of motion to strike, which the court denied on May 24th and May 26th. Interesting. I would have to go look at the rules. The trial court erred in refusing Mr. Depp's proposed jury instructions number 22, 23, and 24. I can go pull those up. Law and Lumber said that's the site where they preserved the issue for appeal, which I appreciate. We just didn't see the other one. Thank you, Rob. Have I made clear that I'm not an appellate lawyer? The trial court erred in refusing Mr. Depp's proposed jury instructions number 22, 23, and 24 as to whether Mr. Waldman was acting as an independent contractor when he made the counterclaim statements. And we can go back and watch that because some of that was argued on the record. Preserved in Mr. Depp's proposed jury instructions 22 to 24, which the trial court denied on May 20th while we were watching. The trial court erred in excluding from evidence the full unredacted versions of Mr. Depp's exhibits 881A, B, and C, which are copies of news articles in which the counterclaim statements appeared, instead admitting only redacted versions to show the counterclaim statements out of context. I'm interested in that too. And I know we have those full articles somewhere. It's just been ages and ages. And then where that's preserved. And that's it. From Brown Rudnick, not surprising. They're a very large firm and probably have lawyers that just specialize in appellate so they can keep it all in-house. But this is a really tailored argument that essentially Waldman's statements and the counterclaims were improper. He's a contractor. And all the things that would support that, the court erred in all the decisions with regard to that. I'm surprised that the media didn't pick up that Johnny Depp also filed a claim. Should I not be surprised at this point? Maybe I shouldn't be surprised at this point. I'd be like, this is clearly what they're doing. But I'm surprised. You would think people would be, I don't know, at least curious about what Depp's grounds for appeal are. But we knew these were the grounds for appeal. With that, we're going to get to just a few questions, and then I have got to go because I have to continue to put things in a suitcase, mostly the makeup I needed to put on today, and then I need to go to the airport in a timely fashion to get on a plane. Thankfully, getting in and out through Nashville's airport is so much easier than getting in and out through like LAX. So at least it's less stressful. Zoe or Zoe, I think Zoe, but I don't know if it'll let you have the 2 dots. Media doesn't care about Johnny. They want Amber to be the victim. They've lost on that. That's not what the jury found. The chat, the media's interpretation of this whole thing was a little nuts. This media is still on the train of Amber Heard is a victim. Eddie said no longer surprised. I mean, same. Morgan, no, you shouldn't be surprised. They tried to bury him for 6 freaking years. It's part of the job by now. It's like they can't just look at what happened at the trial outside of themselves. All right. Let's see. No one in the media even watched the trial. Please, it feels like that. Emily said, please give us updates from BravoCon. I will update BravoCon mostly on Instagram because it's the easiest platform to just get on and share. I will be sharing more behind the scenes over on Patreon at Law Nerds Unite. By the way, let me swoop. We're going to get to, we're going to FAQ around and find out real quick. We're going to just fact around real fast. I will be doing updates over on Law Nerds Unite. If you are a Patreon, you will see those there. I will also be putting updates up in the community tab for the members here on Facebook, here on YouTube. There will be another part to a members only live stream because I had to cut it really short yesterday, which I hated. So there will be a second members only live stream this month. I'll let you know when. I need to take a look at my schedule and see when I can plop that in, and we will talk about all of that. Then I'm going to answer a few questions, and then we are going to, and then I'm going to go get in a car and go to the airport. So I've seen a lot of questions about the Brooks trial. I have not talked about it a ton. I will try to answer some of those questions soon. He's allowed to represent himself. I think there are points where he is pushing that. The court is allowed to revoke that status, that right of him to represent himself, and appoint standby counsel, or appoint counsel. I'm surprised that the court at the beginning didn't appoint standby counsel. That's what was common practice in Los Angeles County where I practice, that when someone was representing themselves, the court would appoint standby counsel that would literally be sitting behind the person and sitting behind them in watching everything go down in case the court said you can no longer represent yourself. I think Brooks has crossed the line into you can no longer represent yourself. The court's not found that. It's very hard to watch someone represent themselves, and particularly when it comes to questioning the individuals that were at the parade, that lost people, that saw this all go down. It's sad. It's sad. So it just makes me sad. Anyway, so question, will you be covering the Masterson trial? I need to see how the reporting is coming out of the Masterson trial. You saw my issues this morning, but I will take a look. I know the DA that's doing the Masterson trial, and they're a great DA. So I'm interested to see. So we will see. Question, have you seen how Bethany Frankel sent a cease and desist to a small TikTok creator for sharing her opinions? I've seen it. I have not dived into it. I saw that Heather McDonald was calling it out. I haven't gotten all to the back. So let's see. Let's get to, I'm going to speed run questions. Replay crew from San Diego finally catching a live. Glad to have you here. Good morning from Granville, M. Oh, wait, does that say MI? Sorry, Michigan. Good to see you. It was great to see you on H&H this morning. It was nice to be in the chat. 3 of my favorite people in one place makes for a great morning. Always a good morning with the law crew. I saw some law nerds using your name as justification for things you may not agree with. Should I send you a DM about it? Please, please do. If I haven't said something, don't use my name into stuff. I can speak for myself, and B, when it comes to things going on around the interwebs, I tend to deal with it person to person, and the law nerds know how I deal with things. Facts, not fuckery. No name calling. Love the show. Always wanted to let you know the way you pronounce etc. with an X sound always triggers me. Sending love from China. I'm sorry. Etc. No, it's etc. It's probably actually etc. No, I don't intend to trigger. LA question, any chance you will do a reaction to Heard 2016 Depo dropped by incredibly average a couple months ago? You would make it hilarious. Seriously, it's nuts. I don't know. I've been so busy. I don't know. So it's within my realm of possibility, but I don't know if I will do that. That is kind of the stuff I do on members only live streams, and that might be the appropriate place for that. First live stream in a long time, drinking Dr. Pepper from Atlanta. Hello, neighbor. Question, what do you think about Alec Jones paying? I don't think he's going to pay them. I think this case is going to be on appeals for 100 years. I think, well, not actually 100, but I think the Jones case and verdicts are going to be on appeal for a very long time. So Pam said, had a 2.0 earthquake in Maryland. Not that common. No, not common at all. The ground shaking is a very unique and specific feeling. Caught an old video of you. 3 words that will change your life. That's my TED Talk. It is an older video. My TED Talk, I think, is from 2017. It's on the TEDx channel. And I really like my TEDx talk. It talks a lot about how I went from, high school to law school to district attorney's office to here. Well, not to here, because in 2017, I still was not really a presence online. I was doing consulting, but I had stepped away traditionally from the practice of law. And it talks about that process. It's a hard process. Stepping away traditionally from the practice of law was a very emotional practice. So thank you for sharing. It is out there. I'm very proud of my TED Talk. I don't love the camera angles at all, but I'm proud of it. Macy said, kids napping. Yay. Emerald City Mystic. I'm in the hospital and so appreciate hearing your humor and logic. Thank you. Please recover well. I hope you are doing okay. And we will send all of our thoughts and prayers for speedy healing and wise doctors to you. Annette said, Amber cannot stay in the spotlight without keeping this crap going. That might be a part of it. Clicks and views. I believe we need the soundboard for this one. Law and Lumber, we definitely got some soundboard today. I know it's off subject, but dying to catch you live to ask, why is the jury in the Kristen Smart trial able to ask questions to the court and people testifying? Thanks, love your content. This is a court-by-court decision. Sometimes it's governed by local rules. There are some local courts that allow the juries to ask questions. I think it's a mixed bag. I can absolutely talk about that more at another time, but it is a mixed bag letting jurors ask questions. Why? Because sometimes jurors will ask things that are not legally proper questions that will elicit an answer that they can't elicit. And then jurors can get really frustrated, like, grounds, why can't I ask that question? I'm curious. But it also is a huge service for the attorneys to know where they haven't explained well or what the jury's thinking. So it can be a mixed bag depending on how the court does it. But generally, the court explains to the jurors, look, some questions we might not be able to ask, but we will ask what we can. And I like seeing it done by written note. It lets the jury be involved. I know it's not her, but Elaine. Yes. Sassy Emily is the best. Thanks. We're feeling sassy this morning. Will Johnny's side respond? Molly T, not to this. When there are appellate briefs, so what will happen next is there will be appellate briefs filed. There will be objections. There will be replies, and it will go to the appellate court. And then the appellate judges will decide, or at least that should be the process. It could just be on the briefs that the appellate court decides and then asks for response depending on the jurisdiction. I need to look at Virginia's jurisdiction more. Law and Lumber knows better than I do. He tweeted about this, but this will go to the appellate court. So there is a group, and I saw a question. Karen, this is not a dumb question. Will the same judge do the appeal? No. Appellate judges are different judges, different court, appointed differently. And they only review what the trial court did because they're reviewing whether another judge erred. Most of the times when judges review their own error, they're like, we good. So this goes to a separate court and to a panel generally of 3 or more judges that will decide the appeal. So that is a completely separate court, completely separate judges who didn't watch the trial, who are doing it all on transcripts. They can ask for oral arguments. Some courts always have oral arguments. Some courts only do it if the parties request. It just depends. Is this going to be on TV? Lori and Rebecca both asked. Well, sort of. If it goes to oral argument, those are often streamed. If oral arguments on the appeal are streamed, I will break my rule of not really streaming appellate court and Supreme Court arguments and cover this one because we're so deeply invested. If oral arguments happen, if it's streamed, that will be way down the road. The appellate court does not watch the trial at all. The appellate court goes by the evidence presented by the parties in document form. Moon Owl said, will the original judge be questioned? Not like a, hey, Judge A, why'd you do this? No, it's all based on the record. They will, in their minds, say, did the judge do this right? Did the judge not do this right? So there is a questioning aspect to it. That is the appellate court. Should we overrule you or not? What did you decide? Were you correct? There is judgment in that way, but they will not ask Judge A. All of it will be done by the record. And you will see this in the Brooks trial. The court says repeatedly, I'm trying to make the record clear. The Brooks trial is going up on fucking appeal. Oh, and then it switched to my wrong mic after I unmuted. Sorry, y'all. Wrong mic. Still muted. I've told all kinds of stories. It switched to my wrong mic. Sorry, everybody. Elaine, your mic. It's because I'm in a hurry. I don't know what happened. Apologies. Sorry. What did I say? I said, thank you. I said, I don't know what I said. I talked about a lovely flight attendant that I had on one of my flights who knew me, which was great. So we're back. There we go. What else? That's about it. So will Judge A, I have to go back in my brain. It's the problem with ADHD. I can't remember what I just said. Judge A will not have any part to do with this. I know I said a lot. I'm so sorry, y'all. We're back on sound. Sorry, Facebook. I'm actually having to go. Apologies. It just is. Elaine, your mic. I don't know what happened. It switched mics on me in the settings, which is so annoying. Anyway, so I saw my mic going over here. I thought it was okay. This is what happened when we rush. With all of that, Judge A is not going to really have any part. Judge A preserved the record. It's what we're seeing in the Brooks case. The judge saying, I'm preserving the record. Yes, preserving the record is important. The appellate court bases everything off of what they have to read. The filings by the parties, the court's rulings, the transcripts and the hearings of the arguments, the transcripts of the trial. They don't watch the trial. They don't watch it on TV. They do everything by transcript. Can you see how boring appeals are? Everything by transcript. So that's what they're doing. With that, I'm sorry that I have to go. I've got to leave my house in just a few minutes. I appreciate all of you. I'm so sorry for the muting issues. I'm sorry. So I'm sure we will timestamp me muting myself. Sorry. And I will talk to you soon. All right. I will catch up on all things law. If you see stuff that you want me to talk about, it's okay to tag me on the socials. Shoot me a DM. My email's public. You can shoot me an email. My team will flag it. We have a lot to talk about, but I'm going to be at BravoCon until the middle of next week. So for now, we're going to talk about that. Bobby said, it's all good. Thank you. Safe flight next time. For all of you asking about Parkland, no, I've got to go get on a plane, unfortunately. So I will try to keep up with it and do some shorts. If you're not subscribed to Emily D. Baker Quick Bits or don't follow me on TikTok or Instagram, that's where I put the shorts. I will do as many shorts as I can to keep up with that. But I've got to go travel. I will see you guys in the next one. Thank you for being here. Thank you for being a law nerd. You guys know how we do it. I will see you soon. Thanks for keeping it classy, law nerds. You guys are truly the best community on the internet. And I appreciate, you have no idea how deeply grateful I am for you. The mods and I talk about this. Y'all show that we can just be the adults on the internet. And I deeply, deeply appreciate you for it. All right. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.